Good morning. Welcome to this presentation by the Portage County Treasurer's Office and the Financial Wellness Fair. My name is Andrew Popp. I am a local attorney focusing my practice on elder law, estate planning. And today we're going to be discussing estate planning in Ohio and review some basic documents that pretty much everybody needs to have in place, both to make sure things are taken care of while we're still around, as well as obviously after we eventually pass away. All right. So again, there's me. I am a licensed attorney, both here in Ohio as well as in Florida. So if there's any need to have, I think there's a lot of people that do the snowbird thing, and believe me, I don't blame you. So if there's assets that need to be addressed in Florida or Ohio, one of the things about an attorney is that you need to be licensed in each state that you're going to be performing work in. All right. My practice includes primarily elder law, so that's estate planning, which we're going to be going through today, which is wills, trusts, powers of attorney, probate, things like that primarily. I'm involved in the community, including the local bar associations, some local senior service associations, things like that. All right, so when we talk about documents we need, what are we talking about, right? Is it documents for insurance, for your car, for your home? What is it we're talking about, right? The focus of the presentation today is estate planning. So I think the first question we need to answer is, well, what is estate planning? I hear people all the time coming to see me and they say, well, I don't know how much I really need because I don't have an estate, right? It's kind of a misnomer. So your estate is the word used to describe things you own in your name whenever you pass away. Now, some people may have a more modest estate than somebody else, but everybody owns something whenever you pass away. And whether you have a significant amount of money and assets or not, planning is important because even for more modest estates, part of the problems that we see is that the assets are insufficient to cover the cost of going through things like probate. Just as an example, I had a gentleman that I assisted, we finished up about probably a little over a year ago. The only thing his father owned when he passed away was about $500 in savings bonds and an old pickup truck. That's it. And it's probably worth $500, if that. And he wanted that pickup truck, right? There was a lot of sentimental value. He had memories of him and his dad going down to the fishing hole, and he wanted that truck, okay? Here's the problem. You got maybe $1,000 worth of assets, and with nothing in place, the cost to put it through probate, about $2,000. I don't like that result. I don't want you to have to do those things, right? Planning in advance can help prevent those types of situations, right? And these things are not difficult to set up on the front end, but if we leave them unaddressed, it could be a snowball going downhill, right? So what do we think about when we think about planning and getting some documents in place to make sure you are taken care of and your family's not stuck going back and forth to court for years and years, potentially, okay? So today, number one, and this has kind of been true for a long time, it's thinking about what happens to our things whenever we eventually pass away, right? That's what everybody thinks about. You think about a will and where you want your things to go whenever you pass. But there's a lot more to it, right? And I always say there's two sides of the coin for estate planning, right? The one side, yes, we're trying to plan what's going to happen to our things whenever we pass. But kind of care about you while you're still around too, right? So the other side of the coin is what about planning to make sure you're taken care of for as long as we're still around, right? And that's everything from making sure that if you can't make your own medical decision, the persons that you care about and trust can make those decisions for you, as well as where you're going to live, if you need assisted living or not. You're going to live at home with one of your kids, whatever it is. And what about finances, making sure bills get paid. If somebody's assigning you into physical therapy or rehab, they can do that. Let's say something happens to you and they need to hire a lawyer for you, right? You can do those types of things as well. Okay. Government aid programs. I see this most commonly come about in the form of Medicaid, okay? And it's kind of been a shift in recent years, and it's really mostly due to assisted living, where the cost of going to nursing homes has gotten crazy in recent years, and I don't think anybody really saw it coming, including insurance companies, right? The average now for skilled care is $9,085 per person per month. It's huge, right? The problem is, if you run out of money and assets, you're applying for aid through the Medicaid program, okay? But that is not easy to get, and people make mistakes all the time that prevent their eligibility, okay? Additionally, maybe things we can do so that if you go to a nursing home, you don't lose everything before you qualify for benefits, right? Okay, retirement accounts. These are things like pensions, IRAs, 401ks. We look at taxes, when you should make withdrawals and how, other things you can do with those, and finding ways to make sure those get where you want, when you want, kind of as easily, cheaply, simply as possible, okay? Number 5, society has gotten much more litigious, I think, in recent years. And whether we are worried about car crash, where part of the just the way things are, which I think is a weakness of the law, anybody can sue you for anything they want, right? You can have a case where somebody gets into a car crash, it's their fault, but they lie to the cops and say you're at fault, right? And then they sue you, right? Either you or the insurance company pays them to go away, or you're fighting it and you're litigating, okay? I did, in the first few years I practiced law, I did criminal prosecution. So I was in court, I was in trial all the time. And if you're fighting it, it's going to go to trial eventually unless you decide to settle out, right? They say about 2/3 of court cases go the way they should. The other third, usually not. It's whether there's a ruling by the judge, that fancy lawyer tricks, whatever that kind of stuff is, whatever it is, which is good and bad because that's still a big percentage of cases that go the wrong way, okay? And there's things we can do if you want to protect yourself from those types of results, okay? Income tax planning, again, kind of ties in with things like retirement accounts, looking at things like the tax brackets to determine how you can get the most out of whatever assets you have while paying the least amount of taxes possible. In my opinion, we all, unless you're Bill Gates, we all pay plenty of taxes during our lifetimes. And if we can find ways to make sure we don't pay more than we need to, I think it's a worthwhile endeavor, okay? Estate tax planning, now this has changed somewhat in recent years. As of January 1st, 2013, there's no Ohio state estate tax. So that's good, but we are still left with the federal, which we may have to think about depending on what assets you have and how they're situated, okay? Funeral and burial decisions, okay? These are very commonly misunderstood. People think you can do those in a will, or hey, if I have things done with the funeral home, I'm covered. Not true, okay? There are very specific requirements under the law to address who can make funeral and burial decisions. I've had cases where there was prepaid funerals, but the persons involved didn't agree. And guess what? If the proper paperwork's not done and they disagree, that prepaid funeral is thrown in the garbage, okay? Family dynamics, what do I mean by that, okay? In figuring out how any inheritance is going to get down to kids, grandkids, friends, other family, whoever it is, okay? I think taking an honest and objective look at them and their circumstances is very important to make sure the inheritance gets to them, 1, and 2, actually benefits them, okay? What do I mean by that, right? And there's a whole variety of situations that we can try to address, okay? Whether they are on disability now or could be in the future, right? Maybe you get injured, whatever it is, and you're on something like Medicaid or SSI, okay? If you're on those programs and you get an inheritance, guess what? You're kicked off your benefits program, right? You're disqualified because now you have too much in assets. That inheritance you're trying to leave to that person goes to pay for whatever the state used to pay for till it's gone, and then hopefully when it's all said and done, they can try to reapply and get benefits back. In the meantime, it's thrown them for a real loop, and the inheritance you're trying to leave that person is gone to Uncle Sam, okay? But you could address things to people who are maybe unlucky in love, where you could have where they get an inheritance, then get a divorce, and then guess what? That divorcing spouse gets half the inheritance, okay? You have beneficiaries who are young or just not good with money. There's a whole variety of circumstances that we can try to make sure we address to ensure what you want to have happen happens and that it actually benefits who you want to benefit. Which ties into number 10, right? Which is everything from those types of circumstances where there's car crashes, even other types of needs-based programs, and it kind of depends, but even things like scholarships sometimes, where if they have too much, they can be disqualified for financial aid or certain scholarship programs through college, right? What if you have, and I say special belongings, Title II firearms, right? Which are short barrel rifle, short barrel shotgun, automatics, or silencers. You need to address those in a specific way, otherwise they get surrendered again to the state, okay? What if you have valuable animals or antiques or collections or things that either need to be addressed in a certain way, they're valuable, or that you just want to make sure maybe there's sentimental value and you want it to go to your granddaughter or whatever it is, right? There's a lot to it, right? So what happens? We get overwhelmed, right? We should talk about our final arrangements so our kids aren't burdened with it, right? Well, why do we care? That's their problem. Well, at least we talked about it, all right? Don't let that happen, okay? All right, so when we don't have a type of plan in place, we're kind of relying on whatever the law and politicians have put in place whenever the need arises, okay? So what things are we left scrambling trying to address, okay? Number one, if you have trouble managing things, no one's available to help, okay? Now, what I always say is this. Everybody needs help sometimes, right? I think half of the battle is that when I hit a speed bump, I have friends, family, somebody else around who's willing and able to step in and help me out when I need help, okay? That's half the battle, right? What's the other half of the battle? Having all the legal red tape done so they actually can, okay? What do I mean by that, okay? If you need help with somebody, trying to make sure bills get paid, right? And by the way, please, please, please do not name a child on your bank account, okay? That is one of those common mistakes that I see where we do action here to accomplish this goal, and guess what? Here's Mr. Unintended Consequence, okay? When you name a child as a co-owner of your bank account, you've just given them half of the assets in the account, okay? What does that do? Number one, we have to think about the IRS and the IRS's gifting rules, okay? You have annual limits and a lifetime limit. It's going to impact those, okay? What else? If you now or in the future would need needs-based assistance like Medicaid, like SSI, guess what? That gift can come back to bite you, okay? And not just now, currently, if you were to need Medicaid in the future, because maybe you do need assisted living at some point, and again, it's like 69% of us are going to go to nursing home at some point in our lives. It's becoming much more of a common issue, okay? They look back for all gifts 5 years. So if you do this, and then 4 years later, you need Medicaid, guess what? You're going to have a penalty. You're not going to be eligible, okay? Please don't do that, and there's better ways to accomplish that goal, okay? What else have you done? Well, you've at least doubled your liability, because now, if that child of yours has any issues in their personal life, guess what? Your money is subject to their liabilities. So if they get sued, car crash, divorce, creditors, whatever it is, your money in that account is liable for their debts. And it may not be anything that are even done intentionally. It's just things that happen in life, or it could be a car crash. Who knows what could be, right? Okay, what else? Medical decisions, right? Now, as long as I can make my own medical decision, I'm the one making it, nobody can override me, okay? But if I am unconscious or incoherent, who's my voice for the doctor, okay? Unless we have documents to say who is, you don't have that right to make that decision. Nobody else does either, okay? Assisted living, am I going to live at home? Am I going to live in an assisted living? Am I going to live with a child? What's going to happen, right? And again, this is if you can't manage things for yourself, who's going to make those decisions, okay? One of the big reasons why we do some of these documents, and we're going to get into powers of attorney, is because if these things need to be taken care of and they're not done, the only alternative is guardianship. You become a ward of the state, you lose most of your rights, and somebody else has to report to the court and manage things for you. Okay? Last, like we discussed before, taking care of things like signing contracts, hiring professionals, physical therapy, whatever it is. Okay? What else happens? Probate. Okay? Whether it's for guardianship or to determine your assets, probate's necessary. Okay? Now, there's 3 reasons I find that people commonly say we want to try to avoid probate. One is that it's expensive, right? Between legal fees, court costs, executor fees, appraisers, inventories, accountings, yada, 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 it's somewhere around 10% of the value, whatever goes through probate, just disappears into the system. Okay? That can be huge. Average, just shy of $13,000 to go through probate with your estate. Okay? Why else? Probate is all public record. So it means anybody and everybody can see exactly what you have, what it's worth, who's inheriting what, if somebody claims you owe them money. I mean, all those details of your life are out there for the whole world to see forever. Okay? Not a huge deal for some people, for others, certainly is. Okay? Last is that probate takes a long time to get through, right? Average is 12 to 18 months to go through a probate. Okay? Could be shorter, could be a lot longer, unfortunately, just depending on what happens. Okay? All right. So guardianship we kind of hinted at just a minute ago. Guardianship, again, it's the court supervised process where someone else is named guardian over you and you become a ward of the state. That means that they're reporting to the court, usually at least twice a year, and the court has to approve everything in advance. If they want to manage your money, pay bills, sign you into a certain living facility, the court has to approve everything. They act as what's called the superior guardian. Okay? And when the court gets involved in your life, they really don't ever get out of it. Okay? The only ways guardianship are usually terminated is that if that person passes away, regains competency, which is very difficult to prove, or they've basically lost all their money and are broke, and it's not economically feasible anymore to do it. Okay? It's expensive. It can be embarrassing being pulled into court if you're in bad shape, inconvenient, all those types of things that we discussed. Okay? All right, what else happens without planning? Your family doesn't know what you want to have happen with any of your things, right? So pets, cars, homes, family heirlooms are just very common examples of things that we want to figure out what happens. And even if it's just dividing it amongst your kids, we got to make sure it's done right, okay? So by that same token, if they don't know what you want to have happen, you don't have the ability to say what happens. You don't have control over it. What happens to it? Whatever the law says, whatever the politicians have made the law say at the time at which you die. Okay? The executor has some discretion over that, but who's that going to be? Who's managing the estate? If nothing's done, you can't say who's doing it, right? What about those final arrangements? Do you want funeral burial services a certain way? Do you want cremation? What do you want and where and how? Just a prepaid doesn't do it. We need the legal documents to say who is the one to make sure my wishes are followed. Okay? All right. This is what we've been waiting for, right? All these things can happen. What do we do about it, right? All right. So, again, 2 sides of the coin. While we're still around, these are the documents we use, okay? Financial power of attorney. That is for financial, legal, or contractual issues. It's making sure, whether it's for convenience or because you're laid up for a few weeks, whatever it is, that the person's named can handle things like paying the bills, sign contracts for you, hire professionals, lawyers, accountants, whatever it is. Okay? Healthcare power of attorney, similar document. That's obviously about healthcare decisions. Okay? Now, going along with that, we need to address HIPAA, okay? That is a common thing that gets missed whenever drafting these documents, okay? So HIPAA is the federal law that says my medical information is private and confidential, and nobody can get a hold of it unless I say so, right? Well, guess what? That includes spouses, children, and others, okay? Here's the problem. Healthcare powers of attorney don't get around HIPAA, okay? So what happens? You go to a hospital, one of your spouse, your child, whoever it is, calls the hospital. Hey, I hear mom's got admitted. I'm the power of attorney. That's my mother. How's she doing? Checking the computer. No HIPAA. I can't even tell you if she's here or not, okay? I always recommend doing one in advance, a general HIPAA release that'll work anywhere you need to go to make sure, at a minimum, those persons named as the power of attorney can actually act for you, because it just makes sense, right? It's hard to make a medical decision for somebody if the doctors won't talk to you, right? All right, living will. Now this one may not be essential, but I always address it because it's always asked about in a hospital setting, and the laws have changed a lot in recent years, okay? So living wills have a very narrow scope, right? They only apply to artificial life support, and really it's about termination of life support, okay? What a living will says is that if something happens to me, let's say I get into a car crash, okay? I'm taken to whatever hospital's close by and looked at by 2 doctors. If those 2 doctors think I'm permanently unconscious or terminally ill and I need life support, living will says don't, period. Doesn't matter what spouse, kids, power of attorney, anybody else says. A living will is me saying in advance, if these 2 doctors, probably strangers, if they think I'm permanently unconscious, I'm just gone, okay? Now, the other way to address that situation is up here in the healthcare power of attorney, right? That says, if the same situation arises, before those doctors do anything irreversible, like pulling plugs, they have to talk to the healthcare agent. And you have the ability, if you want, to have a voice in that decision. You can always say, I can't, I'm just going to defer to you, doc. Or I think more importantly, pump the brakes. I don't know that mom is permanently unconscious. Let's get another expert in here, do some tests, or even just wait a day or 2 and see if things improve, right? Now, there's no right or wrong way to set that up. Obviously, life support decisions are very difficult to make. The danger is this. People come to see me all the time and they have both a living will and the healthcare power of attorney. And guess what? They conflict, right? Healthcare power of attorney says you can have a voice about life support. Living will? No, you can't. The way Ohio has resolved the conflict that exists, living will supersedes power of attorney. They're pulling the plug, and it doesn't matter what you say, okay? That's the reason why not all my clients do it anymore. Whatever is in here, basically, the healthcare power of attorney can do as well. All right, trusts. We're going to get into trusts a little bit. Trusts are great tools that can benefit a lot of people, but not everybody needs them either, okay? It's similar to a will, but unlike a will, there's no probate, assets pass through quickly, simply, cheaply, but obviously there's just the cost setting up a trust, okay? All right. What documents are used after you pass away? This is where the will comes in. And yes, unfortunately, wills do require probate, okay? People will get that wrong all the time. And it's probably just differences in jurisdictions, different states, different years, things like that. But wills require probate, okay? They give you control over what happens with your things, and they allow you to modify or supplement the rules about how probate proceeds to make it easier, cheaper, simpler, quicker, things like that, but you still need probate, okay? Trusts, again, trusts can be used while you're alive as well as after you pass away to handle inheritance. And this last one, declaration of disposition of remains. That is the only legal document, only one, where you can say what's going to happen as far as funeral, burial, cremation, services, those things, and who's the one to make sure those wishes get followed through, okay? That's it. Anything else is not legally binding, okay? All right. So what happens when somebody passes away? The moment somebody passes, a power of attorney is void as of that second, okay? We need to figure out what assets are there and how they're going to get down to kids, grandkids, whoever else you've named. If there's beneficiaries, that's when those are going to be effective when you can fill out claim documents to get those taken care of. If there's something jointly owned, and as long as there's survivorship rights, when one owner passes, they'll get title transferred into their name. If anybody's going to claim that they were owed money by the person who passed away, they have 6 months to present that claim in writing to the executor of the estate in probate. And if they don't, with very few exceptions, they're out, and they cannot come back and try to claim they were owed money. Okay? And like I said, your will needs to be submitted to probate court to open probate for any assets that are subject to the will. Okay? If there's a trust, similar process. They call the process of taking assets in a trust and getting them out to heirs, trust administration. Okay? Probate, and we've said it a few times, wills do not avoid probate. Okay? Is there a better way? Well, yeah. So what's the limitations of a will? Probate's required. Wills allow you to say where something goes, but that's it, right? So if there's a beneficiary who's on benefits, who's going to get divorced, who's not good with money, and they're going to get it according to the will, too bad, okay? But there are things we can do if we want, okay? The original will is required by the probate court, so make sure if you have one, you need to keep the original in a safe location, okay? If you don't have a place, you can technically file it with the county. They keep it in a sealed envelope and charge you $25, okay? Number 4, just because the way wills go, there may be litigation because you're going through probate. Okay. All right. Trusts. I like this. I have major trust issues. Father didn't leave me one. Okay. So what is a trust? Trusts are based on a contract law. You give much more control over how your assets are managed and get down to heirs. What the heck does that mean? Right? Basically, a trust is just, it's a box. It's a way to hold title to assets. Okay. So what does it do? Give the ability to determine not only where something goes, but who, what, when, where, why, how's it to be managed, to make sure it does what you want and gets to your beneficiaries how you want, okay? We have trusts we can do to protect your assets, right? To make sure if you get sued, if you go into nursing homes, you don't lose those assets before you'd qualify for other benefits programs, okay? 3, trusts avoid probate, okay? That means if you have assets that are in the trust when they're going down to somebody else, you're not fighting for 12 to 18 months. You're not paying 10% or $13,000, whatever it is. You just do it. Okay? Tax benefits, depending on the type of trust, you can play with some of the tax rules to receive benefits for heirs, for you, maybe some charitable donations, things like that. Okay? All right. Once these are done, what's the next step? Well, keep it updated, right? They say every 3 to 5 years is a good time to come in and just have them looked at, okay? Because what happens? All these things. Families change, relationships change, finances, for better or worse, change, especially in the past couple of years. And the law, right? I always, again, we blame the ultimate scapegoat, the politicians, right? The law changes almost every year, I feel like. Why? Well, a politician will say that they did something when they were in office. What did you do when you served? Oh, I changed the law to do this, this, and this. You know, next guy changes it back, but hey, look what I accomplished when I was in office, right? All right. In a nutshell, why is this planning important? What things are we trying to do, right? Save money, okay? Obviously, there's some cost in setting documents up, but it's typically a lot cheaper to set it up in advance than fight through whatever needs to take place when things aren't done, right? Make sure that whenever any of us have difficulty or have issues, the persons we want to be able to step in can. Okay? Keep family matters private and confidential, okay? Keep it out of probate if we can, or at least minimize it so that your personal business is not out there for everyone to see, okay? Avoid arguments within the family. Make things, this is a very common goal, keep it easy, simple, quick, those types of things, and save time, right? At the end of the day, it's all about you and your family, making sure you're taken care of and making sure you're not leaving a mess, okay? At this point, if we have any questions, we'll take this from the audience, from those of us online. Thank you for joining us. If you have any questions, you can get my information from, I believe, this video. If not, Legacy Law Firm, again, Attorney Andrew Popp. Thank you very much.